The highly publicized death of Brittany Menard, a 29-year-old California woman with terminal brain cancer who moved to Oregon to legally end her life, reignited the right to die debate and resulted in California becoming just the sixth state to pass right to die legislation. What are the key concerns? And now that it's law, where do we go from here? We'll ask Dr. Ben Rich, professor of bioethics at the UC Davis School of Medicine, Deborah Doctor, legislative advocate for Disability Rights California, and Tony Anderson, executive director of ARC of California. California's right to die legislation, facing an age-old question.
Additional funding for the Maddy Report made possible by a grant from The Wonderful Company, harvesting health and happiness around the world, and by Kaiser Permanente. Thrive, from the California Channel at the State Capitol and the Maddy Institute. It's the Maddy Report, with Executive Director of the Maddy Institute, Mark Kepler.
Death is an inescapable part of life, but do we have the right to choose the manner of our death? Our guest is Dr. Ben Rich, Emeritus Professor of Internal Medicine and Bioethics at UC Davis School of Medicine. Welcome.
Thank you.
So, right to die legislation has been attempted and failed several times in California. Now it's passed. Why now?
Several reasons. I think the story of Brittany Menard galvanized public attention about this.
And she was the 29-year-old who had
Right.
terminal cancer, had to leave California to go to Oregon
Right.
to...
Right, and she invested a significant part of the last months of her life to support the right that she said she should not have to leave California to exercise, to take control over her dying. We've now got experience of 18 years with the Oregon Death with Dignity Act, 8 years with the Washington Death with Dignity Act, and all of the reports suggest that they're working exactly as they were designed and intended to do. The California
So when you say that, you're saying that the abuses that people were concerned about aren't materializing?
They are not. And it's because the evidence was so compelling after just 10 years that no less than the American Public Health Association took a formal public position supporting laws like Oregon and Washington and now California, saying these laws empower patients at the end of their lives and they do not threaten vulnerable people.
Well, let me ask you this. Some people are questioning whether this law is even necessary. You know, you do have the right before this, you had the right before this law to sign these DNRs, do not resuscitate, that they said that those give people the kind of the requisite control over the end-of-life decisions. What do you say to that?
Well, DNR specifically, I mean, that applies to cardiopulmonary arrest.
Exclusively?
Yes, it means when a patient goes into cardiopulmonary arrest, do not resuscitate or do not attempt resuscitation. You know, there are many other ways in which you can meet the end of your life in a less dramatic way, a less intensive way. And people want control over that that they don't have now.
Well, let me ask you this. Can you distinguish medical aid in dying and euthanasia? How are they different?
I think the simplest way to do it is physician aid in dying is empowering physicians to write prescriptions for lethal medication at the request of a competent patient. Usually when we talk about euthanasia, we're talking about voluntary active euthanasia, which means a patient who cannot do what the California law would require, which is to actually ingest the medication themselves.
Okay.
But they have decisional capacity, they meet all the other criteria. Where that were legal, they would be able to get assistance with that.
So in euthanasia, you may have someone else actually going through with the action, but in this medical aid in dying, the person, the individual makes that decision. That's the critical difference.
They make the decision and they take the action.
And they actually do take the action,
Right.
correct. Okay, so what about the religious and disability rights advocates? You know, the concern here about coercion and abuse. What safeguards are in this new legislation to make sure that that doesn't happen?
Well, first of all, you have the implicit safeguard of what we would call the learned intermediary. You have a physician who has all of their professional obligations to comport themselves consistently with the standard of care, with the canons of medical professionalism to benefit the patient, to help the patient pursue their goals. They have to meet a whole host of criteria, not just by one physician, but by two, determining decisional capacity, that they're not under undue influence. They've worked well in these other jurisdictions, and there's absolutely no reason to think they wouldn't here.
You know, it's interesting that I found, what I found interesting in this law was this 10-year cap, that they're going to reevaluate in 10 years. That's pretty unusual for a law.
It's apparently what was needed to get the requisite number of votes. It's, in a sense, imposing a timeline in which we will really test, is this working the way it's supposed to?
Let me ask you this. You know, there's some saying that this law is really a distraction. What the real problem is the low quality and low access to palliative care, making sure that end of life is a smooth transition. What do you say to that?
I say look at the Oregon data. The overwhelming majority of the people in Oregon who utilized the Death with Dignity Act were enrolled in hospice. Clearly, hospice was not meeting their needs as they saw their needs. I don't believe they were simply people who got involved with the wrong hospice, who were receiving substandard palliative care. Hospice is a wonderful opportunity. Palliative care is excellent, but it is not a panacea for everything patients encounter at the end of their life.
So in your opinion, it doesn't solve the entire problem?
No.
Okay. Well, thanks for explaining the reasoning behind California's right to die legislation. Up next, what do opponents think? That conversation in a moment. This is the Maddy Report. The right to die debate has strong moral and religious overtones. There's also a concern about what this law could mean to the physically and mentally disabled. Our guests are here to discuss those concerns. They are Deborah Doctor, legislative advocate for Disability Rights California. Welcome.
Thank you.
And Tony Anderson, the executive director of ARC, which is a group that's trying to help the developmentally disabled. Welcome.
Thank you.
So Tony, let me start with you. It seems like this is a medical issue, or is it more than that? Is it also an ethical and religious issue? And if it's the latter, if this is an ethical or religious issue, should we just leave it to someone's own ethical or religious beliefs?
Yeah, that's a good question, because we hear that argument quite a bit. In our association, we don't see it as an ethical issue or a moral issue at all. Actually, we see it as a human rights issue, a protections issue. So
Okay.
we're representing people with intellectual and developmental disabilities. And so we know that there's a historical problem in terms of the treatment of people with developmental disabilities. And we know that there are plenty of places where there won't be enough protections in place. So to us, it's a protections issue. It's not a moral. It's more of a civil rights issue. And then in terms of medical, in some cases it could be medical as well, because we're part of a group of people who are regularly diagnosed with a prognosis of a short lifespan. We have many people in my association. Family members will tell you that their son or daughter, when they were young, were given a very short lifespan, guessed by the doctor, and yet today they're living in their 30s and 40s in wheelchairs.
Let me ask you this, Deborah. Right to die legislation seems to have strong popular support. 69% of Californians in a poll recently favored physician-aided death. So why do you think this law that they passed is not a good idea?
Well, I think that, the question was asked about to the population about the general topic. And my organization focused on the legislation. So I think that you can't assume, that 69% of the people understood and supported this piece of legislation. And the legislation has several flaws in it, which, as Tony said, lead to, possibility of misuse. I mean, our concern is that it doesn't have enough protections in it. It's based on some theories that are not necessarily correct, starting with, as Tony said, the idea that a physician can accurately predict death. And we know that, in some cases, obviously they can, but in many cases, they cannot accurately predict it. So that's the first problem. And then there's a whole series of protections which aren't in there and which we feel lead to the possibility of abuse or coercion.
Yeah, I want to get to that in a moment, but I want to ask you another question. What about the concerns you often hear from cancer patients who fear death marked with uncontrollable pain and suffering? They want the option not to go through that.
And I understand that, and this has been a difficult discussion, but what we have to, my organization has to think about is the entire population, and if there's a possibility of abuse for some people, we can't support public policy. And I know that there are individuals who are absolutely wanting this, and our concern was not about the people like Brittany Maynard, who had a wonderful, supportive, loving family who were following her wishes. But there are hundreds of thousands of cases of elder abuse in California every year. We're concerned about the people whose families are not acting in their best interest.
Well, let me ask you about, the law is supposed to have some safeguards, right? 2 doctors, has to be, 15 days in between the request, has to be self-administered. Aren't the safeguards sufficient?
I don't think they are. When you think about, the doctor can be somebody who just met the patient 5 minutes before. I mean, this is not somebody who necessarily has had a long-term relationship with the patient and knows the dynamics. And we'll find that some doctors and medical groups won't participate in this at all, which means that people who use those doctors will have to find somebody else. So that's an issue that they might not have knowledge. And then there's this issue of the 2 people who are supposed to say that the person is
the
in
witnesses.
Right, but they could be somebody who met the person 5 minutes ago also, and one of them can be an heir. One of them can be somebody who has a financial interest.
Okay.
And it's giving people who are possibly strangers an enormous responsibility to make a judgment about free will with no background, no training. Notary publics have to get trained, and all they're doing is saying the person is who they say they are.
Well, let me ask this, Tony. A lot of times the proponents cite the Oregon example. Law has been in place for 17, 18 years. Empirical evidence doesn't seem to support the notion that people are being coerced into taking their own lives. Well, how do you respond to that?
Well, first of all, DREDF, the Disability Rights and Education Defense Fund, has a great document that shows that it's not quite the case that there's no problems in Oregon or Washington. They cite many different cases where somebody has, the doctor has said that they don't think that the person is they think they're depressed. They have clinical depression. And they also feel, in some cases, that there's some coercion, where they sense that there's coercion going on. And in some of these cases, the families have gotten a second opinion, gone around the doctor, and then in the end, the person was given the medication and died. So these are protections that are in place. They're supposed to help, and yet they're happening in this way.
So some questioning about the data. Well, thank you for explaining your concerns about California's new right to die legislation. So where do we go from here? That up next. This is the Maddy Report. So where do we go from here? We're talking to 2 opponents of California's recently passed right to die legislation. They are Tony Anderson, Executive Director of ARC, and Deborah Doctor, Legislative Advocate for Disability Rights California. So, Deborah, let me ask you this. There are some progressive diseases, Parkinson's, Alzheimer's, ALS, that generally don't come with a terminal diagnosis within 6 months. So there are those that say this law doesn't even apply to a large number of people.
But in Oregon, people with ALS are getting the lethal dose. And in Oregon, there have been a few people who got the lethal dose, who took it in 2014, but were prescribed it and received it in 2012 and 13, which shows that the prognosis was not accurate.
Yeah,
Some of them lived 2 years past their expected date of death.
Yeah.
So it is very hard to predict. It's not something that is easy to do, and it's not foolproof.
Tony, obviously this law has been drafted and it has some ambiguity, so there's going to be regulations to implement specific provisions of the law. Are you focusing on any particular regulatory issues that might be a particular concern?
Right. Well, we're still stinging from the loss on the signing of the bill. We never really thought he would sign it because it went through a special session under different rules, right? But what we are doing is we are getting together with the disability community. I represent 2% of the total population developmental disabilities, but 20% have a physical disability in general. So we're a larger group, and we are definitely getting together, and we'll be mapping that out. Now, we still don't think, we're going to be looking at protections in place. We know that there are millions of protections in place for people with disabilities. There are regulatory agencies and things in place for people to not be harmed, and yet they're harmed at a much higher rate than any other group in society. So no matter what you do in terms of adding the protections, it's not going to be something that we would be completely in support of, but we would find ways to try to add some protections in there. But it's not going to make us comfortable.
It seems to me your concern is really protecting what you view as a vulnerable population.
Right.
Yeah.
Right.
What about you, Deborah? Are there certain regulations that you are concerned about as they kind of flesh out this law? And
We're going to definitely try to get in as many protections as we can. There are, there's still some hope, I think, to get in some additional protections, some oversight. One thing that should be done is the state should take an active approach to oversight and not just depend on people voluntarily reporting. In Oregon, when people say that there's been no evidence of abuse, well, abusers are unlikely to report their abuse. And there is no third party required to be there at the time of death. So nobody can assure you that there was no coercion.
So let me ask you this, Deborah. Do you think this is going to be challenged in the courts?
I don't know. At this point, we're, as Tony said, still kind of recovering from the fact that it got signed and thinking about, what we can do to protect people. And there may be a court challenge in the works, but that's not necessarily connected to my organization. I don't know.
Okay. So Tony, the other option here is to file something in the November ballot, and apparently there's a group called the Seniors Against Suicide. They filed paperwork for a referendum on the November 2016 ballot to overturn the law. They're going to need 365,880 signatures. It's a lot of signatures.
Yes.
To qualify for the ballot. Do you think they'll get the signatures? Do you think we're going to be seeing this in the November 2016 ballot?
Great question. I think that, if anything, it gives us a chance to talk about the issues and all their complexities. And I think what you find in some cases is that people change their mind when they learn all of the issues that are involved. When you just explain it on face level, people take the reaction that they take, where they fear the uncontrollable pain and the terrible situation that is real for everybody. But in fact, when you lay it all out, people do tend to change their mind. So you could have a turning in the public opinion once that gets out there.
We've only got about 30 seconds left in the segment, but I want to ask you, what are your thoughts on a proposition in November?
I think it's an uphill battle to get those kind of valid signatures.
Because you're going to need twice as many probably just to make sure that those are valid.
Absolutely.
Right?
And as Tony says, it might give us an opportunity to get kind of the other side of the story out there.
Yeah, well, thank you for that conversation and articulating your position on the issue. Up next, what is the response of those who supported California's right to die legislation? That conversation in a moment. This is the Maddy Report. How will California's new right to die legislation work, or will it work? We're talking with Dr. Ben Rich, professor of bioethics at UC Merced. Studies show that doctors are overly optimistic in their assessment about how long their patients are going to live. So we got this 6 month to live requirement. Is that even necessary or useful?
Well, it started with the advanced directive legislation, living wills. Back in the 70s, they put that in. It's part of the hospice benefit requirement. It's arbitrary. I don't think it's capricious or groundless.
I know, but they did kind of pick that 6 month out of thin air. I mean, there's no magic to that number.
There's no magic to the number, except that you can say that this patient is genuinely, to the best of our medical knowledge, at the end of their life, relatively speaking, and they need to be making plans accordingly.
Yeah. Are you at all concerned that this might implicitly encourage people to take their lives rather than spend money on these expensive end-of-life treatments?
I'm not. Once again, I say...
You're going to point me back to Oregon, aren't you?
Look at the Oregon experience. the Washington experience. I mean, the fact of the matter is that people desperately want to live, and they will go through incredible hardships and challenges to live as long as they can with a minimally acceptable quality. That's why even an organization like the American Hospice and Palliative Care, the American Academy of Hospice and Palliative Care, the physicians who are caring for these patients, they have gone on record and said it is inappropriate to characterize this practice as physician-assisted suicide. The people who are making these decisions are not suicidal. They are attempting to control an imminent and inevitable death.
Right. You have to accept the inevitable. I think a lot of people have a hard time with that. I was reading some research somewhere that said that people, when people see other people die, it reinforces the notion that they think they're never going to die because it's happening to someone else.
Go figure.
Yeah. So what about the regulations that are going to have to be drafted to kind of make this law work? Are you concerned about any specific regulations that are going to be drafted in this regard?
I think that, we talked earlier about the sunset provision. I think that it's going to be very important to have the procedures in place to ensure that the documentation is timely, is thorough, and will give an adequate picture that this statute is working as intended. I think the more important thing, which is less formalized, will have to do with educating healthcare professionals about this new law, this new opportunity for patients, so that they can comfortably, if they have no conscientious objections, make this available to patients.
Just as an aside, I'm a little curious. In medical school, do doctors get training in this regard?
Not generally. Now, it may be that in jurisdictions where this has been in place for a while, they may have it. I know there's talk here about saying it when this becomes law, we can't allow our students to cultivate their ignorance of this. That would not be acceptable, as in any other area of practice.
It would seem to be a pretty important thing that they'd want to cover in medical school. Well, what about this law being challenged in the courts? Do you think it would, if it is, would it survive judicial scrutiny? And you have in addition to a PhD, you have a law degree, so you can look at this.
I'm going to sound like a broken record, but the Oregon law was challenged, and its implementation was delayed for several years. It survived all those challenges, and I would fully expect that the California law would too. I would just call that to the attention of anyone who thinks that it would be anything more than a delay tactic.
Right. I mean, this law also is not going to go into effect until after the special session is 91 days, I think, after the special session is over, and the special session isn't over yet. So we don't know exactly when in 2016 it's going to be implemented.
We don't.
Last question is about a referendum. Some folks have filed papers for a referendum of the November 2016 ballot to overturn the law. Are you at all concerned that this law might be overturned?
Now I am a broken record, but you know what happened in Oregon? They passed it in '94 by a voter initiative. I think it was 51 to 49%. Somehow it was able to be thrown back to the electorate again. They supported it in a much larger percentage, 60 to 40, basically saying to those who threw it back at them, what is it about what we said the first time you didn't understand? The California public overwhelmingly supports this law. And
you don't see that changing?
I don't think so.
All right. Well, I want to thank Dr. Ben Rich from UC Davis, as well as Tony Anderson with ARC, and Deborah Doctor from the Disability Rights of California, all of them for joining us. If you want to stay current with state and local politics, you can follow the Maddy Institute on Facebook, Twitter, or logging onto our website at maddyinstitute.org. This is Mark Kepler for the Maddy Report. Thanks for joining us.
The views expressed in the Maddy Report are those of the individuals participating in the program and do not necessarily reflect those of the California Channel or the Maddy Institute. If you'd like to share your thoughts about the points and opinions expressed on the Maddy Report, visit our website at maddyinstitute.org.